Hello, my name is Michael Teeter and I am an attorney at Safe Harbor Estate Law. Recently, because of an opinion of the Minnesota Court of Appeals in the Guyan case, there is a new tool available to those people who are looking to shelter assets from having to be spent on long-term care expenses in their advanced years. This tool is called a Medicaid Asset Protection Trust. In another video, I have discussed the Guyan decision and I encourage you to watch that video. When it comes to Medicaid Asset Protection Trusts, there are a number of different ways to structure this type of trust. But one term that it must have is that there is no circumstance under which payment of the trust assets can be made to the grantor's estate, or for the benefit of the grantor or the grantor's estate. Although case law is still developing in the state of Minnesota because these trusts have been forbidden in the state of Minnesota for many years, in other states, this prohibition of payment from the trust assets to the grantor has not been held to extend to beneficial enjoyment of the trust assets by the grantor. So, for example, the grantor of the trust could live in a home owned by the trust, and so long as the grantor was paying for all of the upkeep related to the home, this would not be considered a payment of trust assets to the grantor. The alternative to a Medicaid Asset Protection Trust, which has been used in the state of Minnesota for many years, is to simply gift the asset away, often to a trusted child. There are numerous advantages to a Medicaid Asset Protection Trust over doing this. The first advantage of a Medicaid Asset Protection Trust has to do with capital gains taxes. When somebody makes a gift to another person, the person receiving that gift takes that gift with something called carryover basis. Carryover basis basically means that the person who gets the gift has the same basis for capital gains tax purposes as the person giving the gift. So, for example, if somebody purchases an item for $50,000 and then they sell it for $100,000, they must pay capital gains taxes on the difference between what they bought it for, which is called their basis, and what they sold it for. In this case, that is $50,000 of difference. However, if someone receives an asset as the result of the original owner's death, they take that asset with something called a stepped-up basis. A stepped-up basis means that the basis of the item is stepped up to the value that it was worth on the date of the original owner's death. A Medicaid Asset Protection Trust has the ability, depending on terms and circumstances, to maintain this step up in basis that occurs when the grantor of the trust dies. This means, for example, that if the children of the grantor are receiving the assets, they will, instead of receiving carryover basis, they will receive a basis that is stepped up to the value of the asset on the date of their parent's death. The other major advantage of a Medicaid Asset Protection Trust has to do with spendthrift provisions. Spendthrift provisions are something that we put in every Medicaid Asset Protection Trust that we do here at Safe Harbor Estate Law. These provisions prevent the creditors of a beneficiary from invading the trust principal to satisfy that beneficiary's obligations. If you make a gift simply to one of your children, and that child gets into a car accident, that child has medical issues, that child runs into financial troubles, or that child gets a divorce, the gift that you gave to your child is going to be at risk as a result of those circumstances. A Medicaid Asset Protection Trust protects the gift in these circumstances. Here at Safe Harbor Estate Law, we use Medicaid Asset Protection Trusts in two different scenarios. The first of these scenarios is pre-planning. This is for individuals who are young and healthy enough that it is not likely that they will be needing long-term care in the next 5 years. For these individuals, we will customize a Medicaid Asset Protection Trust to their desires. Then we will make a gift to that Medicaid Asset Protection Trust of the assets that they wish to go into that trust. Finally, we will wait out 5 years before applying for Medicaid. Once those 5 years are up, we can apply for Medicaid, and those assets that were gifted away over 5 years ago cannot be considered in determining Medicaid eligibility. The second scenario in which we use a Medicaid Asset Protection Trust is in a crisis scenario. This is a scenario where somebody is already receiving long-term care or will be in the near future and is looking to preserve some of their assets still. We have a tool called a gift annuity plan that can often preserve a large portion of an individual's assets. This plan divides a person's assets into 2 different portions. The calculations to determine these portions are extremely complex, and it is something that we regularly do at Safe Harbor Estate Law. The first of these portions is called the gift, and this consists of the assets which are to be gifted away and preserved for future generations. The other portion of the assets is used to purchase something called a Medicaid compliant annuity. A Medicaid compliant annuity is a very special type of annuity that is treated as income and not an asset for purposes of Medicaid qualification. Oftentimes, the gift portion of the gift annuity plan is given to a trusted family member. This is because a portion of the gift needs to be available to be given back to the person giving the gift during the penalty period that the gift incurs. However, in some circumstances, this doesn't make sense because of various family issues and dynamics involved in the case. Depending on the exact circumstances, in these situations, we at Safe Harbor Estate Law may recommend a Medicaid Asset Protection Trust to hold the gift portion of the gift annuity plan. This is because the Medicaid Asset Protection Trust deals with various family dynamics that can create issues in a gift annuity plan. So, for example, family members may be going through a divorce, or they may have financial difficulties, or they may have medical issues, or there may be simply family dynamics where there is not trust between the members of the family. In these situations, we may recommend a Medicaid Asset Protection Trust to hold the gift portion of the gift annuity because this type of trust will deal with those situations. A Medicaid Asset Protection Trust is one of many tools that we use at Safe Harbor Estate Law to shelter a person's assets from having to be spent on their care expenses in their later years. Whether or not a Medicaid Asset Protection Trust is the right tool for you can only be determined by meeting with an experienced Medicaid Asset Protection attorney. We at Safe Harbor Estate Law have extensive experience in Medicaid asset protection, and a Medicaid Asset Protection Trust is just one of many tools that we use to assist clients in protecting their assets from having to be spent on care expenses in their later years. If you are ready to begin protecting your assets from the nursing home, please call our office to set up an appointment.